Under Section 42A of the Trademarks Act 1995, an application to register a trademark must be rejected if it contains or consists of a scandalous matter. The definition of scandalous used by the court is the common one from the dictionary, being scandalous indicates the causing of a significant degree of disgrace, shock, or outrage. What constitutes a scandalous matter will shift in accordance with the community standards, changes in demographic makeup, and time. For this reason, the courts have been reluctant to define exactly what a scandalous matter is. The courts do, however, look at a number of factors including the context that the trademark appears in and the scope of the scandal. Concepts such as causing offense depend directly on context. For example, something shouted in a church will be considered offensive, but if it was shouted as a greeting, it would not be offensive. Therefore, the context of the trademark will be considered, as while it may seem offensive at first glance, it may not be to the person who will, as a customer, be directly exposed to the use of that trademark. A trademark must be scandalous to a substantial number of people for it to be rejected. The fact that a trademark may have some scandalous connotations to a small group of people will not be sufficient. To satisfy this test, it is sufficient that not an insubstantial number of people will be or are likely to be shocked. When considering those who would be scandalized, the registrar looks at the broader world community, illustrated by the rejection of Mecca for registration, with the registrar stating that although the population of Muslims in Australia was not significant, the public appreciated its secondary significance and it could offend entire nations as well. There are few examples in Australia of trademarks being challenged on the basis that they are scandalous. In home box office, the trademark abso-fucking-lutely was rejected, but they were later able to get around this by changing the spelling to abso-for-cucking-lutely. The word pommy basher was also successfully granted registration, as it was argued that instead of meaning a person who bashes poms, it is in fact slang for a person who insults English people, particularly in the game of cricket. Trademarks which are overt phonetic equivalents of obscene words with little or no modification in spelling are likely to be refused registration. This is clear in the case of fucked and cunt, which were refused registration in Australia. When trying to register cunt, the applicant tried to argue that it was similar to FUCK, which had been accepted. However, the registrar found that FCUK, while suggestive, was an acronym and incapable of pronunciation, whereas KUNT was a clear phonetic equivalent to an offensive word. A good example of both changing community standards and an insubstantial number of people being scandalized by a trademark is the trademark look good, feel good, root good, which was not rejected for registration, with the judge stating that contemporary language, both spoken and written, is more robust than it was even 10 years ago. He went on to state that it may be in bad taste, but in ordinary circumstances, it is not in itself likely to cause any significant degree of shock.